Ask Ana Barreira, founding director and lawyer at the IIDMA is International Institute for Law and the Environment. Yes, adjunct professor of international environmental law at the IE University.
It's already said, but I'm the founding member of IIDMA, and it is 28 years ago. It was founded 28 years ago, and we have been doing a lot of work in the course of all these years in many areas, biodiversity protection, environmental democracy, water protection, ocean protection. And since 2010, we have been focusing a lot on fighting climate change and energy transition. And the name of our organization is because for us, international law is the source of all obligations and provides the guidance for what states are doing to protect the planet and to fight environmental degradation. Because I'm a believer on international cooperation. I mean, it's we have sovereign states. We have the limits of sovereignty because we live in a planet which is ecological interdependent. And also regarding my position as environmental law teacher, international environmental law professor, I teach in the Instituto de Empresa AI, which is an international university based in Spain, in Madrid. Okay, so in the program, my presentation, it's entitled like multi-level governance and enforcement of climate laws in Spain. I have to tell you that in general, lawyers, we tend to believe that enforcement only takes place in courts. And when we were doing the project, that's the project, we were looking at the database of Sabin Center, the cases that were identified in Spain. And what we realized is that it doesn't is consistent with the definition of climate rights that we were managing, because most of the cases that are identified, only 17 cases in Spain, there are cases that relate to allocations of climate emissions under the ETS. So for us, and there was another case that was identified as a climate case in Spain, what was a case on an oil spill in the north of Spain. So for us, that is not considered a climate case. So in Spain, we only had as it is today, the understanding of climate case was a case before the Spanish Supreme Court by a group of NGOs, but it was a fail. I mean, the Supreme Court, it didn't judge or didn't rule in favor of the plaintiffs. The defendant was the Spanish state, and it was about the NECP. But for me, there are other cases, like cases that we have brought IIDMA regarding the national transition plan on thermal plants, coal power plants. We were doing a lot of litigation on coal power plants in the past, but today what I'm going to concentrate is more on implementation in Spain of the Paris Agreement and of all the international, of the international legal regime to fight climate change. And why? Because we have to, as lawyers, we need first to recognize that law has its own limitations, and particularly in countries as Spain, where we have a civil law system. So under our civil code, the judgments of courts are not the main source of law. That is not what happened in common law systems. So even if you go to the Article 46 of the European Convention on Human Rights, only judgment of the European Convention on Human Rights abides to parties in the case, in conflict. So not the whole members of the signatures or the parties of this international convention. And also we are always talking about rights. For me, as lawyers, we have always to, this is like yin and yang. It's all rights are next to obligations. If there is a right, there is an obligation. Recently I was doing another research on climate rights. Climate rights, rights of nature. And I was shocked because people, they are not understanding what rights of nature implies. It's not only about rights, there are also obligations, but this would be another topic, or another presentation, which I would love to do it. But as today, we are here at the Committee of Regions, I want to talk about multi-level governance. This is very important. So could you please go to the next slide? Okay.
Yeah.
Okay. So I'm going to give you the background, and I'm going to talk about the Spanish case. So let's go to the next. So first, we have to see what the Paris Agreement says in its preamble. I mean, of course, preambles are not legally binding, but the Paris Agreement already recognized the importance of the engagements of all levels of government. So we need to take into consideration that states, they go to international negotiations, but they go home because multilateral environmental agreements, international law has to be implemented to make it a reality at the national level. Without without national action, the international commitments, it's just, as I said, law is paper till things are being done, okay? And therefore, here we are at the EU level. I mean, we are members of the European Union, and under the Paris Agreement, and that is one of the novelties of the Paris Agreement, it's that it's took a bottom-up approach compared to the Kyoto Protocol and the UNFCCC, where there were command and control. I mean, these are your emissions limitations. You have here Annex B in the Kyoto Protocol with your limitations, with your commitments, your targets of emissions reduction. But under the Paris Agreement, countries, they have, and in this case, all members of, or all signatories of the Paris Agreement, they have to prepare the NDCs. That this has been translated at the EU level to through the regulation on the governance of the Energy Union to what it's called the NECPs, the National Energy and Climate Plans. Okay, so, and we will see why it's so important, the action of regions and municipalities, because of the 5 dimensions of the NECP. Because the 5 dimensions of the NECP, which are decarbonization, which it's about mitigation and energy, I mean, renewables. It's about energy efficiency. It's about energy security. It's about the internal electricity or energy market at the EU level, and also innovation and research. So in many countries, these of the EU, and in many others in other parts of the world, the powers to make action, to develop policies and laws lies in different levels of government. So let's go to the next. So I'm going to talk about, of course, which is the title of my presentation, it's the case of Spain. What are first? We need to check first what are the climate commitments of Spain, because this is first dimension of the NECPs, and of course this is part of the commitments also as Spain, because Spain is also a contracting party of the UNFCCC, the Kyoto Protocol, and the Paris Agreement. So we have the EU level, we have targets in the field of climate mitigation, in the field of renewable energy, and in the field of energy efficiency. That, by the way, I want to recall that last year, under the exercise of the first global stocktaking, what it has been called the Dubai Consensus, there was an agreement that to help the transitioning away from fossil fuels by 2030, the presence of renewable energy has to triple and energy efficiency has to double worldwide. So that's why the EU under the Repower EU increase all these targets. So here you can see that Spain has targets that has been introduced in the Spanish climate change law, which is LCCTE, in the climate change and energy transition law. But we also have those under the NECP. If you know, and if you see, every country has different targets, because at the EU level, we are acting since the Kyoto Protocol in this bubble system in which, and under the principle of common but differentiated responsibilities that has been already commented by Jake Worksman, also this works internally at the EU level. So we have different commitments, and Spain has stronger commitments in renewable energy than even the EU, but it is not the case for mitigation, but we have increased with their review of the NECP. That I must say that in Spain, our targets, they are legally binding. The lawyer that talked from Estonia, she was explaining us a case in which she was mentioning that NECP targets are not legally binding, but in Spain, first we have all these targets in the Spanish climate change and energy transition law, but now they have been increased. The law has not been amended by the NECP, has been adopted. Their update or review has been updated by a royal decree, which is a regulation, what means that the targets are legally binding, and there could be a case before, because before a court of law. Could you, I don't want to read all the targets because you can read perfectly the presentation. So can we, and I don't have the time. So having said that, we have to go to the case of my country. My country, under the 1978 Constitution, it established it divided the territory in municipalities, provinces, and autonomous communities. And the Constitution recognizes the autonomy and of regions to manage their own affairs. And the Spanish Constitution has also distributed competencies regarding amongst the autonomous communities that and the state, the national level. When we talk about autonomous communities, it's a kind of, we are a quasi-federal state, and autonomous communities is quite similar to for Yemeni landers, and they have a lot of, they have a strong level of powers. And for municipalities, we have a different law. But when we talk about fighting climate change, there are many matters that are related to fighting climate change. These are energy issues, environmental protection, or for example, okay, Shaba is leaving me alone, so I don't know where it's there. Okay, anyway. Okay, so for example, in energy also we have to talk about land planning, and we have to talk about agriculture when we want to reduce and mitigate emissions, but also when we want to deploy renewables. Like for example, in the case of energy, it's quite complex, the system. Like I will provide you an example. The state is competent to grant authorizations for those projects that are whose power is higher than 50 megawatts, whereas will be the autonomous communities, the ones that provide authorizations for projects that are below 40 megawatts. But in addition, if we talk about deployment of renewable energies in areas that are already artificial or where there has been human intervention, the best places are buildings. And for buildings are municipalities, those that have the power to grant authorization. So this is just an example. For environmental protection, the national state has the competence to produce environmental protection rules or legislation, but autonomous communities, they can develop those national laws. They can do it even stronger. And in addition, they have the power for executing the law. So they are the ones that are granting permits. Okay, I have to run now. So for example, here it's complex because now with the Renewable Energies Review, the Renewable Energy Directive 3, states, they have to design, to identify acceleration areas. But acceleration areas, in some cases, you have to take into consideration biodiversity protection. And our autonomous communities, the one that have most the competencies for biodiversity protection. Land planning, the national state has no almost powers, are the municipalities and the autonomous communities. So can I go? Okay, these are, let's go because I don't have the time. These are some examples of how, so Spain has its own climate change and energy transition law, but several autonomous communities, they have already developed their own climate laws. And the first one was Catalonia, even before the Spanish state, but here you have a list. I don't have the time, so let's go. But not only climate laws, but the Spanish climate change and energy transition law also ask, come on. They can, the autonomous communities to notify then at the national level through a climate change policy coordination commission, their own energy and climate plans. So autonomous communities, they have also developed strategies and a kind of NCP. So here, can we go to the next one? Yeah. So, okay, there are, I don't have the time, but there are even some autonomous communities that they have a stronger targets for climate mitigation, for deployment of renewables, even stronger than those of, and not for energy efficiency, they stayed at the same level as the Spanish government or the national level, but some they are even stricter than in those targets for renewables and for mitigation than the Spanish state level in their plans or strategies, okay? So my conclusions, because I don't have the time to go further, the roles of regions and of municipalities cannot be underestimated. They play a very important role to fight climate change at the time of implementing, and therefore these laws can be also enforced. And of course, without their action, the Paris Agreement objectives won't be attained. Of course, we need also companies, as we have seen in the previous presentation. And I just want to bring a sentence that was very much used during first Rio conference. I was then a student in London. It was 1992 Rio conference on the United Nations conference on sustainable development. And it was think globally and act locally. So I would say think and commit globally and act locally. So thank you, and I'm sorry I cannot provide you more details in my presentation. And I forgot to mention, we have been working on this since at IIDMA, analyzing all the regions' policies and plans. We have 17 autonomous communities. In the last 4 years, we are doing a follow-up constantly on this, and now we are reviewing all the commitments of the autonomous communities. So thank you very much for your time, for listening to me. Thank you.